Please be seated. We'll hear argument in 21-941 PNC Mortgage versus Howard.
May it please the court, Mr. Lemke will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, just last year, when this case was previously before this court held unambiguously that when a refinance lender's foreclosure claim based on the refinance lien is time barred, that does not preclude the assertion of an equitable subrogation claim. In other words, the refinance lender, time barred on the foreclosure claim, can still resort to equitable subrogation. The court then sent the case back to the 5th District Court of Appeals to determine what is the accrual point for the statute of limitations on an equitable subrogation claim. And the Dallas Court of Appeals held that the accrual point for the equitable subrogation claim is the same as the accrual point for the foreclosure claim based on the refinance lien. That is, it is the maturity date of the refinance loan.
Or when it's accelerated.
That would be an accelerated maturity.
Which moves up the maturity date.
Yes, that's correct,
And
Justice.
the Fifth Circuit has now said that as well in Lamel, so why is that wrong?
Well, the Fifth Circuit in Lamel essentially said this court was going to take it up, and they changed Lamel from a published to an unpublished opinion, and on remand, that district court case it's on hold. It stayed pending this court's decision.
Right, but even in the second Fifth Circuit decision, they say basically the same thing, that the accrual date is when the acceleration happens.
It is wrong, Justice Busby, for multiple reasons based on foundational principles of equitable subrogation doctrine as espoused by this court. First and foremost, it's the LaSalle case. And what LaSalle said was that the equitable subrogation claim does not derive from its contractually refinanced debt and accompanying lien. Well, that seems to be in direct contravention of what the 5th District Court of Appeals said, where they're saying the statute of limitations accrual point is derived from the refinance debt.
Well, but I guess the question is, I mean, if you're standing in the shoes of the original lender, which I take it to be is what happens with equitable subrogation, how do you know when you say I'm accelerating the obligation here, how do you know if what you're accelerating is the new note or the old note?
Well, I think there's only one note for purposes of this doctrine. This discussion that we're saying that there are still two notes, that's not correct, but I do think...
Well, then how would you know what the original maturity date was? Why would you look at the original note?
Well, because that goes to the Zepeda decision by this court, and which is the latest in a long line of cases, saying that the refinance lender steps into the shoes of the original lender and has the same rights, no more or no less.
Right. I understand all that, but did you accelerate the underlying note in this case and make it due? The original note?
The original note, the acceleration notice, to my recollection, does not reference an underlying note. But I think
so you don't have a claim for foreclosure then on equitable subrogation because you've never accelerated the original obligation?
Well, I don't think you accelerate the original obligation. The question, I think you have to look to the original note and see, is it
in the record? Can we look to the original note?
The original note is not in the record, but as we point out, the issue of whether it's barred by the statute of limitations is an affirmative defense, and so the burden would have been on the Howards to put the original note in the record in support of their claim of a statute of limitations bar.
Well, they say you're suing us for foreclosure and you've accelerated, that makes it mature. And so your response to that is?
Well, what they're saying it is mature, and what we say is that even if it was accelerated, the Dallas Court of Appeals failed to take account of the fact that based on their holding, the statute of limitations would run on the equitable subrogation claim before it could ever have been asserted, which that can't be right.
Well, the amicus brief from the TPTLA says that's exactly right, and it puts the responsibility where it belongs, which is on you, basically that way everything's within your control. You can assert your claim timely or not, but their position is if we go with the rule that you suggest, that there are going to be traps for the unwary out there, and some refinancing lenders are going to get stuck with no remedy. What's your response to their brief?
My response to their brief, first of all, is that they're wanting to really cast aside the fundamental principles of equitable subrogation and suggest that they get a lien for the length of their loan as opposed to how much the original lender had left on his lien. But as to the point about the trap for the unwary, I think a lot of their argument is really a backdoor attack on this court's ruling in Howard 2, where this court has already said the fact that you did not timely assert your refinance claim based on or the foreclosure claim based on the refinance lien, that does not preclude you from asserting equitable subrogation. So I think they're really attacking that ruling that this court said equitable subrogation is still available when there is a time bar due to the fault of the refinance lender. And I think the answer is, if there is an equitable subrogation claim separate from the refinance lien foreclosure claim, as this court held in Howard 2, how can it possibly be the case that the claim for equitable subrogation is barred before you could ever assert it? Because the law is clear from LaSalle up until the ruling in Howard 2 that you only have an equitable subrogation claim when the refinance lien is infirm. And in the case of
But how could it be the case that claim has still not accrued? Your claim, I don't understand. It seems like it's got to be one way or the other, right? You've either got to, if you make a request for an acceleration on the refinance note, that's either also got to be considered a request for acceleration on the original obligation to which you're equitably subrogated, or it's not, and you have to make a separate request for acceleration on the original obligation, which you didn't do, so it's not mature, and you have no grounds to foreclose.
Well, I think the issue is, does the original loan even have an acceleration clause in it? That's what
and we don't know, because it's not in the record.
We don't know, but the basis.
But then your foreclosure claim fails.
Well, let me go back to the question you asked a second ago about how could you not have the clock running. This court held in LaSalle, you don't have the equitable subrogation claim until there's no adequate remedy at law. There is an adequate remedy at law with regard to the statute of limitations, up to the point that the statute of limitations bars the refinance lien foreclosure claim. It is then and only then that you could ever assert the equitable subrogation claim. And so
rather than fixing an accrual date as of the date of the maturity of the underlying loan, would it be the accrual date is the date that the predominant loan is declared invalid?
I think for purposes of the equitable subrogation doctrine writ large, which often includes constitutional defects that are where the infirmity is obvious from the get-go and there's no interim period where there is an adequate remedy at law, the accrual point then makes sense that it's the maturity date of the original loan. But to your point, in the statute of limitations context, I think whether you call it, I think there's a tolling concept that has to come into play, that there's no way that you can have the statute of limitations running on the equitable subrogation claim before you could assert it. Because as a result of the 5th District Court of Appeals ruling, you could, even though this court said you can resort to equitable subrogation to overcome the statute of limitations, you never could. So I think you have to say in the context of the statute of limitations that there is an equitable tolling concept that you're not going to have it. So effectively, yes, I think the result will be, with regard to a statute of limitations bar, it's at the moment the legal claim becomes barred, that's when the 4-year statute of limitations would start to run.
Did you ask for equitable tolling in the trial court?
We stated throughout that the adequate remedy at law was was a requirement before the claim could be asserted. I'm not sure we used the term tolling, but we talked about the equitable doctrines associated with the absence of the ability to assert the claim until there's an adequate remedy at law.
And that would be your burden if this is equitable tolling.
Yes, I mean, we would have to, if they presented evidence, first of all, we say they never met their burden on the statute of limitations defense because they never referred to the maturity date of the original loan. But I think I'm not sure it's even a burden question because it really is just the question of when it starts to run. That's almost as a matter of law that it can't be running until you can assert the claim.
Is the bundle of rights that you're equitably subrogated to track to the lien or to the terms and condition, every term and condition of the original loan? I think the Howard side says it's the lien and the enforcement of the lien that equitable subrogation grants, but not necessarily every term and condition of the underlying loan. Not the maturity date, not an arbitration clause if it was included in there, not other various terms and conditions, but just the lien and the amount due and owing on that lien.
I think this court has drawn a distinction between a procedural issue. In Crowder, the court said, well, the procedures for foreclosure that come up under the new foreclosure document, the new refinance deed of trust, that controls. But in terms of the fundamental issue of could the original lender have asserted the lien, I think that is the Zepeda idea of you step into the shoes of the original lender. And so if the original lender, for example, if it was a 30-year loan and they're 29 years into it, the original lender only had 1 year left to assert the lien. It would be a massive expansion of the rights if the refinance lender could then, if it was a 30-year refinance, have a 30-year resort to that equitable subrogation lien. And so I think it's the fundamental point of it's mid-continent, this court's decision mid-continent, and then again in Zepeda, that you get the same rights, no more and no less. Now on the procedural stuff like arbitration and venue, this court has said on that, for the foreclosure proceedings, the refinance deed of trust controls.
Let's say that equitable subrogation didn't exist as a judicial doctrine. Could you accomplish the same thing by contract in the refinancing documents?
Well, there are often contractual subrogation clauses that exist, but I'm not sure the concept of the equitable tolling would come into play in that. But the contractual subrogation issue is not really presented.
I understand. Just imagine a world where there's no such thing as equitable subrogation, but you want those same rights. Could you contract for them?
Yeah, absolutely. There are often contractual subrogation clauses.
So what is, and this is just backing up to first principles, what is equitable about the court giving you rights that you have not contracted for?
Well, I mean, this goes back to the 1880s and the fact that Texas has always taken the most robust view of equity.
But I get the precedent, and my question goes to the prior question of why is equitable subrogation equitable when you could contract for it, you could bargain for it, you haven't. Why does the court bail you out?
Well, because it's our reserve parachute analogy that the idea is in order to encourage a robust refinancing market, you need to provide this additional protection because of potential flaws. And in order, it's not only a pro-lender doctrine, it's a maybe not pro-defaulting borrower, but...
So why is the question of whether the refinancing market ought to be promoted a judicial question, a question of equity that a court ought to be concerned with as opposed to a pure policy question? I can imagine all kinds of reasons why you might not want a robust refinancing market. It doesn't seem like the court's got any business basing a doctrine on the presumption that we should promote lower interest rates in refinancing.
Well, certainly no one is urging the overruling of the last 140 years of precedent.
Right.
But I think, Justice Blacklock, what I would say to that is there's this idea that the law has imported that the refinance lender is involuntarily paying off the prior loan. And because of that involuntary.
Which is a total fiction, right?
It is a legal
There's nothing
fiction, but it's,
involuntary about any of this.
I mean, it is not only in Texas, I think that extends across the country, but the notion of equity is if you're involuntarily paying off a debt that you didn't have to pay off, then it's equitable for you to be able to step into the shoes of the original lender.
And that makes sense as an equitable matter, but the involuntariness piece of it is why it makes sense. And there's nothing involuntary about your engagement with a debtor, and the debtor has paid off the original loan. I mean, it's the debtor that borrows from you and then pays off the original lender. You don't pay the original lender, right? The debtor pays off their debt. And I just cannot understand, just as a matter of first principles, why there's anything equitable about that debt that the debtor has paid off continuing to follow the debtor.
I see my time has expired. May I
You may
respond?
answer. Yes, you may answer.
Justice Blacklock, I guess I would say that we're not writing on a clean slate here. And I think that there are certainly reliance interests in this doctrine, and the court has seemed to have recognized for over 100 years that it's important to maintain the availability of equitable subrogation, because it is not only pro-lender, it is pro-borrower, because borrowers who are in trouble need to have resort to the refinance market, and this doctrine makes it more available. But I think that is a bridge that the court crossed decades ago.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Panderi will present argument for the respondents.
Mr. Chief Justice, and may it please the court, I agree that the court needs to clarify something that is important to the jurisprudence of the state, as PNC's interpretation of the line of the federal district cases and the earlier Amarillo case illustrates that has not been understood. Now, I will discuss in a minute why that particular sentence that PNC likes in those cases definitely means something and applies in those cases in a minute. But let me just say what this court needs to clarify is that the payoff of the note changes its maturity date from a future date to the present, just like acceleration of a note does. And there's several Court of Appeals cases saying acceleration changes from a future date to a present date. Now, I will admit that when I first got involved in this case after the remand, I immediately thought, well, excuse me, why doesn't paying off the note mature it? And I couldn't find a case that said exactly that, which is kind of what apparently we need, because when I went to a friend who's an expert in real estate liens, he said, well, okay, that's because maturity date is a very specific technical term that is defined in the note. And for example, this PNC's note says April 1, 2035 is the maturity date of this note. So he said it's not correct to say the payoff date is the maturity date, but it's correct to say there can be no payoff date later, no maturity date later than the payoff date. And so that's what we put in our brief. Now, I will tell you that I tried again to find that kind of case. And when I didn't recently, I talked to the same expert, and he said, well, there probably isn't such a case simply because lenders know that they're not subrogated to the note, they're just subrogated to the lien. So, it's interesting, PNC accuses us of blurring the lines between notes and liens, but that's what they're doing.
What do you, if we don't agree that the payoff date ought to be the accrual date for an equitable claim that arises upon the default of the borrower and the inability to enforce the lien, what do you contend could be an alternative accrual date to that, short of the maturity date of the underlying note?
Well, I agree that the maturity date of the underlying note is it. It's the one that makes the most sense if you don't call that the maturity date. But let me explain what those other cases have found and why that context is there. And it's because those other cases are ones that weren't payoff of loans. They were cases in which the first loan was still active, a home equity loan in two of them, a loan where a husband took out a note on the property without his wife knowing about it, but was a second note, so the first note was still being paid. But let me say, I mean, this kind of goes to their point about it being meaningless for this to have court to have said you can still go back and if you screwed up on the statute of limitations, it would be meaningless. Well, not true, actually. Now, first off, when this court changes the law after the Court of Appeals ruled based on the prior law and didn't therefore get to other issues, this court generally sends it back to the Court of Appeals. But PNC is also not remembering that this court remanded for two things. One, to see if there was something that had to do with the statute of limitations that would apply, and I had already thought about asking for equitable tolling, which they didn't do. But this court remanded also for the Court of Appeals to look at our issue that the language of the PNC deed of trust actually precluded its use of equitable subrogation. That's the big thing on the remand. But when we got back and I got involved in the case, we decided that the implications from this court's other language rendered our argument invalid and therefore essentially dropped that argument. But
Just looking at the assertion of equitable claims in other contexts, like a breach of contract for services, and the alternative relief that might be available should the contract be found to be infirm, quantum meruit. What is the accrual date for a quantum meruit claim that's connected to a breach of contract claim?
it's the same. It's the same. Now, all right, again, they're trying to latch on to a First Franklin note that they paid off, not purchased, to help them with this claim and for future cases to give them a holding that parrots that sentence in those cases that gives them pretty much a wide open period of time to use this fallback. And now equitable subrogation does not mean to give them this broad of a fallback, I think, but it just gives them the right to essentially use the language in that deed of trust. And it was their burden when they come to the court asking for judicial foreclosure, it's their burden to put on the documents that establish their right to equitable subrogation. In fact, that note not being in the record kind of doesn't even tell us something like, guess what, if it was a balloon note or a very short-term note or whatever. There were certainly circumstances where it would not help them at all. So, PNC can't not have it better than the lender whose shoes it stepped into. We agree they stepped into First Franklin's shoes, but if they stepped into Ked's sneakers, they don't get to walk away with Air Jordans. It just does not make sense. And of course, I guess they're just asking you by that to assume, oh, that was a 30-year note, so we get till 2033 before our cause of action even accrues and we have to bring it. So,
and maybe you can help me understand, but if they get that and there hasn't, under their theory, there hasn't been an acceleration of the underlying, and I understand your theory about payoff, but setting that to the side for a moment, if there hasn't been an acceleration of the underlying note so as to make it mature, then how could they sue for foreclosure of the equitable lien?
I'm not sure I understand your question.
I don't
actually.
understand either, so I'm trying to see if
Okay.
you can help me understand.
Okay.
Because it seems like they're saying there are two different liens here, and they can each accrue at different times. And so put aside the refinancing lien, because that's time barred, or at least that's not before us. But if they're suing on the original lien and they want to foreclose, it seems like they have to show the note is mature and it hasn't been paid, right? So they would have had to accept, presumably, if the maturity date of that loan is sometime way out in the future, you've got to accelerate that underlying debt in order to be able to foreclose on the equitable lien, if they're really two separate things.
Right, in which they don't have the right to foreclose on that note. Their name isn't even on it. The equitable subrogation only gives them the right to use the language in that original deed of trust.
Which we don't have.
We don't have, but it also, that makes sense in terms of why those cases say it goes by the maturity date, because they are looking at cases that are still active notes. This is a second lien, but also they're looking at things where, that second deed of trust had an unconstitutional provision the legislature changed. In one of those others, only 3 of the 4 people who signed the original deed of trust signed the second deed of trust. So, there's a big infirmity. So that kind of thing is the whole reason for the equitable subrogation.
But it does seem like if it doesn't accrue until the maturity date, then how can you sue to foreclose an equitable lien that hasn't accrued yet unless you accelerate it?
But you're speaking as if the equitable subrogation claim, and it's not a claim, it is
An equitable remedy.
An equitable remedy, right, that it accrues, or that it attaches to the original note.
And I understand. I'm just
It
taking
doesn't.
them at their theory. I'm not saying I agree with that, but that's their theory, at least
Understood.
that far.
And-
So
right.
I'm just trying to understand how that gets them anywhere, because it seems like then you couldn't foreclose because it hasn't been accelerated.
Well, correct, but, and you don't have a right to do anything with regard to their note. You didn't buy their note. You refinanced their note. So you don't have anything to do with the specifics of that note, nor would they have the ability to accelerate that note. Now, the seriously bad ramifications of the ruling PNC seeks, I will leave to our brief and to the very helpful brief of the TPTLA. I think it is, and it explains why this would be an awful result. But
Would you like to address the other issue that might affect this question, which is whether or not there was abandonment of the acceleration?
Well, actually, I don't think I have the name of the case, but it's interesting because there is a case that says the statute of limitations accrual date would be the same under the equitable subrogation and the PNC's note, absent evidence of abandonment of acceleration of PNC's note. They didn't prove that at trial. They did not prove that at trial. And here's what they want. They want you to give them a do-over on the whole trial so they can go back and find the original note, and so they can argue that they abandoned acceleration, when in fact, actually, looking at the facts, they sent another acceleration notice in 2010 after the 2009 one, which they say then they abandoned, et cetera. So, but I don't think they're entitled to a do-over here. They potentially had help from an equitable subrogation, but I don't think that they should be given a do-over. Now, of course, we're asking this court to affirm the Court of Appeals opinion, clarify things a lot more about the maturity becoming the payoff date when it's paid off. And the Court of Appeals had not They just basically said, oh, we agree there's a conflict between these cases PNC raised and us, but we like the way the old Hayes Supreme Court and Kone decided. Well, again, that's failing to recognize that actually there's not a conflict because those cases were not about paying off liens. They were about secondary liens. So anyway, that was just something that wasn't in there. So let me mention one other thing that PNC argues that it would make no sense if the statute of limitations accrued at the same time. And as I've mentioned, there's a case that says that's true absent acceleration. No. But also, granted, this is an equitable question. It's a common law question, but this court could be informed by Civil Practice and Remedies Code section 16.035E, which is right under the 4-year statute of limitations for foreclosure. It says if the case is based or the foreclosure is based on a series of liens, the date of the last one controls when the limitations accrues. Now that may sound like, oh wait, doesn't that automatically just slap them down? It actually doesn't automatically, because that statute refers to a series of liens. This is not a series of notes, sorry. That would be bank loans me $100,000. Next year it loans me another $20,000. Next year it loans me another $10,000. That's a series of notes. Anyway, but still, it is a good policy reason to have said it can often be the same. Let me just also clarify what happens if this court does affirm. It still ends up in a remand, not a remand for a new trial. In the trial court, that court heard all the evidence, heard everything, had already decided that the foreclosure by the wrong lender who didn't own the note, which forced our people, suddenly their house had been foreclosed on by somebody they had no obligation to, forced them to file for declaratory judgment that was void. And the court, trial court, had already ruled, yeah, that one was void. And so then PNC sues on the note and for foreclosure and all that gets swept in together. So anyway, when we go to the Court of Appeals, it says the trial court was right on limitations expiring on equitable subro. It says the trial court was right in not allowing equitable subro, which is what this court later said no. But the Court of Appeals also said trial court was wrong in not giving PNC a judgment on the note because that's a 6-year statute of limitations. So it remanded for calculation of the note, which we don't deny. It's now over $1.5 million because this has dragged on since 2010 with like 3 years of PNC doing nothing and whatever. But anyway, so yes, the court would need to remand just for calculation of that note, which apparently PNC wants both that judgment and the house. So anyway, that's a whole other issue. So we're asking you to affirm the Court of Appeals decision, but just explain a couple of things in there and explain how, of course, actually the payoff date is the maturity date, but also explain how the cases that PNC likes because they have that good sentence for future use don't really apply anyway. That sentence was fine for those cases. It doesn't apply to this payoff case.
Let me ask you this. It seems like we've got 3 potential dates now at least. You've got the payoff date, you've got the maturity date, and then you've got the date of acceleration, which I guess would be what the Civil Practice and Remedies Code section you referenced says you go by the last note, and so when they accelerated the last note, that would be the date. And you would be okay with that as well, I take it, because that would also mean that the equitable subrogation claim would be time barred, either under that or under the payoff date.
Correct. Well, and yeah, and none of those other dates would help them. Yes, there's a
Except the
potential for
maturity
3
date.
dates, but I agree, it's 4 years from the maturity of, or from the acceleration date.
Right.
And that's what they blew. And we gave them notice of that by filing our lawsuit 3.5 years, I think it is, before they actually made that claim. So I don't think this is the kind of equitable relief that the common law theory encourages.
So, but to be clear, under your approach, the concept of equitable subrogation would provide no value to a refinancer if the reason the refinancer is unable to foreclose on its own loan is a limitations problem. If limitations is what prevents them from collecting on their refinance loan, then there's no scenario in which equitable subrogation to the original lien would have any value to them. Is that
Well,
correct?
I believe there are potentially, you could think of something that does that,
I
but.
can't. So
Yeah, I
can you-
know, and I am kind of back to, I thought about equitable tolling, something else. But, and I will say, I think it's a little broad to say they well, you didn't say they automatically would have a different date. Or they automatically, are still allowed when they screw up limitations to go with the equitable subro. You didn't say that quite directly, but generally, equitable subrogation is for things where, unbeknownst to you, there was something wrong with your lien, and you've been given the right to use the other lien, which certainly gives you plenty of rights to encourage the refinancing industry.
Any other questions? Thank you, Ms. Pendry.
Thank you very much.
Mr. Sutton, I believe you have 5 minutes.
How do other states treat equitable subrogation and the accrual date for limitations purposes?
Your Honor, I think we indicated in our brief, if I'm not mistaken, that a number of other states do look to the maturity date of the original debt, but I'd have to.
There was a lot about what the federal district courts have done in the Fifth Circuit, but I wasn't
All right, well,
clear about
beyond what we have in our.
the general, if there is a prevailing general rule in other states.
If there is, I don't know it. Now, Justice Boyd, make no mistake. The answer to your question is an emphatic correct. They are ripping any meaning from Howard 2 with their position. There is no situation where if the accrual point is the maturity date of the refinance lien, there is no situation where equitable subrogation would give any value, despite this court having held just last year equitable subrogation is the reserve parachute in the context of a statute of limitations bar. Now, interestingly, the Howard said at the very end, well, maybe there'd be equitable tolling. And I want to note, the Howards just now made no response to the point that how in the world can a claim, the statute of limitations be running on a claim when you can't assert it? And they don't dispute it cannot possibly be asserted until the statute of limitations bars the refinance lien foreclosure claim.
But that's the same situation with quantum meruit, and yet we use the same accrual date for quantum meruit as if it was a breach of contract.
Well, but I think you can plead quantum meruit and breach of contract in the alternative.
And you can't plead equitable subrogation and an action on your note in the alternative?
I don't think you can plead, I don't think
We
you
see
can.
that quite a bit.
I don't think you can plead equitable subrogation until there's a time bar. It would be due to be dismissed because there is an adequate remedy at law.
Same with quantum meruit.
This court said in LaSalle, you cannot assert equitable subrogation until there's an adequate remedy at law. And so,
If there's an adequate remedy. at law.
if there's an adequate, yes, sir. If,
So the flip side to my question to your opponent's counsel is, are there circumstances in which a refinancer is unable to foreclose on their lien, enforce their lien, for reasons other than limitations, in which circumstances the ability to foreclose on the original lien through equitable subrogation would still be valuable to the refinancer?
oh,
Right.
I think there are,
So really, the Court of Appeals ruling here basically says equitable subrogation under the circumstances of Howard 2 is really no value.
that's right.
Because limitations bars 2, it necessarily bars 1, but that doesn't mean equitable subrogation as a whole has no value to a refinancer.
That's correct.
Okay.
But
Okay.
I think what's going on here is the Fifth District Court of Appeals was overruled by this court when it said you can never resort to equitable subrogation to overcome a statute of limitations bar. And so then on remand, what the court had said you can't do through the front door, they tried to do through the back by adopting this notion of an accrual point that's the same accrual point as the other claim. So they're effectively overruling Howard 2. And I want to
Let me
note,
take you back to Justice Blacklock's question about the policy reasons behind the doctrine. If taking as a given what we've said, that the policy reason is to encourage refinancing and make credit more available, why would we continue to extend equitable subrogation in a case where that policy cuts both ways, given what the amicus has said?
well, I think that the court has already covered that ground in Howard 2, and another primary policy reason that dates back to the First National Bank of Kerrville case in the 1880s is to avoid unjust enrichment to the defaulting debtor. And so that's another critically important thing.
Why wouldn't that rationale, though, apply equally to the original mortgage? I mean, under that rationale, it's just people should never get out from under their debt, and so we're going to give the lender rights it didn't bargain for to make sure it gets paid.
Well, but I think the issue is it's a defaulting borrower. It's not.
I mean, the original mortgage does not, if the original mortgage holder does not follow the rules, they don't get to foreclose. They don't have this parachute that the refinancer has. The refinancer has special rights. In either case, if the debtor's getting out from under the debt, if there can't be a foreclosure. So I mean, why wouldn't we apply the same rationale to the original debt?
May I respond?
Yes, you may.
Justice Blacklock, I disagree with the premise in that the original lien holder would be able to assert the lien.
But they fail for whatever reason. Statute of limitations or whatever reason they fail to do that. They have no parachute. Is that unjust enrichment that the court should be seeking to remedy?
Well, I mean, my position would be when you have people who've lived in a home for over a decade and not paid a dime in taxes or in mortgage payments, it's unjust enrichment. But I think the point is that, that really, I think, is water under the bridge after Howard 2, because this court said in Howard 2 you can resort to equitable subrogation, and they've not asked for Howard 2 to be overturned.
They have not, and we may need a case where somebody asked for that before we consider it. But it seems to me that if somebody came into court in the year 2022 and said, look, we have a contract with the other party, and we didn't follow the terms of it, but it'd be really unfair if you let them out and just enforced our contract as it's written, and so you need to give us some equitable rights to make sure that we're covered. I mean, you couldn't make that argument with a straight face in 2022 to this court about some other arrangement. And it's just interesting to me that whenever this arose, people approached it so differently, such that this was considered a situation that equity needed to intervene and remedy.
Mr. Chief Justice, may I conclude?
Yes. Yeah.
Look, I take your point, and I guess where I would finish is where I began, which is if you look at what the court said in LaSalle, that the equitable subrogation right does not derive from the refinance contract note or the refinance lien. You can't reconcile that with what the Dallas Court of Appeals did, and the Howards have never, in their brief or today, explained how you can. So we think the case should be reversed and remanded for proceedings to determine the amount owed. Thank you.
Any other questions? Thank you, Mr. Sutton. Case is submitted, and the court will take another brief recess.